Hi Bearcats, this is Gene Roberts with Student Legal and Mediation Services at Sam Houston State University. We wanted to provide you with some information about renting, landlords, and tenants in this age of COVID-19. This is for educational purposes. It's not legal advice, and we really encourage you to speak with an attorney because every situation and every lease agreement can be a little bit different. One significant development in landlord-tenant law is that the Supreme Court of Texas issued its fourth emergency order on March 19th that prohibits eviction trials and eviction proceedings until April 19th. There are some exceptions for that if the landlord can show that you are a physical harm to the landlord, its employees, or other tenants, or you're engaging in criminal activity. But this is designed to put a hold on evictions for a short period of time. Sometimes students are asking if they can terminate their lease because of COVID-19. So there has to be a legal reason to terminate the lease. One possible way is through something called force majeure. Force majeure is a legal concept that says that if there's some sort of event that occurs that's beyond the party's control, then the lease could be terminated. But everything that's outside of a party's control doesn't mean it qualifies as a force majeure. It has to be in the contract. The courts strictly interpret this. And so look at your contract and see if there's anything in there titled force majeure, pandemic, epidemic, things like that. Another legal theory in looking at your contract is the theory of impossibility. And specifically what we're looking at is something called impossibility of performance or a supervening impossibility. At its core, what this means is that if something happened, typically by a law enacted by either the governor, the president, Congress, or the state legislature, that makes the performance of the contract impossible, then you can go to court and ask the judge to declare that your duties under the contract are impossible. So those are a couple of different legal defenses to the performance of a contract. What obligations do you have? It's really important to examine your contract and see what it requires you to do. In some contracts, you're required to notify the landlord of an extended absence. That can be as much as 14 days. And it's important to look at your contract to see how you provide that notice, where it's supposed to be delivered, and whether you have that obligation under the contract or not. In some contracts that we have analyzed, there's a provision that says the tenant must obey all laws. In this context, with COVID-19 and different jurisdictions putting in stay-at-home, stay-in-place type laws, it may be impossible to return back to your apartment complex or your home that you're renting. So this might be a way to terminate the contract because of your requirement to obey the law. Landlords are going to handle this situation differently. Some of them, as you can see in this tweet, are going to be helpful towards their tenants and others are not. And that doesn't mean they're mean. It means that they're trying to enforce the contract as they review it. So one of the things that we encourage you to do is, if you can't move back, talk to your landlord and try to negotiate. Try to see if you and the landlord can reach terms that would allow a mutual agreement to terminate the lease. Before taking any action or talking with your landlord, please talk with an attorney of your choice to go over things, because your lease may be different than someone else's, your situation may be different than someone else's, and those facts are very, very important. We are here and we are still open to help our Bearcat students. We are seeing students by videos and appointments. You can schedule your appointment through Campus Connect or calling our office, and we will help you schedule an appointment. Be safe, know your rights, and take care of yourself.